Hi everyone, my name is Ben Cote and I'm an attorney at Stiles Law. And this week I wanted to put together a video that explains how to terminate a tenancy in Massachusetts. This is the beginning of the eviction process, goes over some of the most important details, identifies some pitfalls, as well as some of the changes in the law due to COVID-19 and some of the laws that have been passed. So let's get started. We have some common sense items we have to go over first. So this is for informational purposes only. This isn't legal advice. I'm not your lawyer unless we sign a fee agreement, and I have the facts of your case to give you legal advice. The presentation relates to Massachusetts law only. So if you're in a different state, your laws are going to differ and you'll have to take a different approach. And this area of law is changing rapidly. There are laws passed at both the state level and at the federal level that affect how to terminate a tenancy and how an eviction will proceed. So do your own research and make sure that this information is still accurate if you're watching this sometime after I've uploaded it. So what is a notice to quit? It's basically a notice from a landlord that it shows the intent of the landlord to terminate the tenancy and gives instructions to the tenant to vacate. A notice to quit in Massachusetts doesn't require any sort of special magical language. It doesn't have to have any sort of buzzwords. It doesn't have to be identical to every other notice to quit, but it does have to be accurate in the sense that it can't be reasonably misunderstood. So, for example, in a notice to quit, we don't have to name a specific date. So if we're trying to terminate a tenancy in March 31st, we can say the end of your next rental term, which is the same thing as March 31st, and that's usually a good idea because it prevents a situation where you might have a typo or a mistake in your date calculation. So for a 30-day notice, oftentimes we'll just put in at the end of the next rental period. The notice must be unequivocal. So this is pretty simple. It basically means you can't send a letter that says, you must leave the premises, but let's negotiate. Or, but if you do this, then you don't have to leave. It has to be unequivocal in its statement that the tenancy is terminated on a date certain and the tenant has to move out. So one of the most important things with a notice to quit is an idea of timeliness. So it means two different things. One, it must comply with Massachusetts law for the amount of time that the tenant is given. We've already talked about that a little bit, but then also the notice must be delivered in a timely manner. So let's talk about a non-payment case. So you must give tenants 14 days or whatever is in the lease, but usually it's 14 days under the statute is the minimum that you have to give in terms of notice. I always add a day or two at the end just to make sure that there's no argument that I've cut off time and actually given them less than a full 14 days. And you'll see why when we talk about this case in a second. Most other reasons that you'd give a notice to quit, so that'd be things for a fault-based eviction. So, for instance, if the tenant is violating the terms of the lease or breaching a quiet enjoyment of other tenants or has damaged the property, something along those lines, that's a 30-day notice. And really, it's an entire rental period. There's exceptions to that, but the bare minimum under the statute is 30 days or a full rental period. The case that I want to talk about on this point is Connors v. Wick. And basically, what happened was the landlord, and this is an old case, but landlord-tenant law has been around forever. And sometimes the old cases are still something that we look at. So the landlord gave notice on the first day of the month and told them to leave on the last day of the month. And the court found that that wasn't actually 30 days notice. They have to give them a full 30 days, not first day of the month to the last day of the month. It would have to be the last day of the previous month to the last day of the next month. And so that's how technical this timeliness gets. If you're off by a day, you're going to have to start over and essentially give a new notice. So I have clients or prospective clients that'll call me on the last day of the month or the last Friday of the month in the afternoon, and they say, all right, I want to send a notice to quit. And a lot of times I have to break it to them that it's even if we could get a constable to serve the notice to quit, they might not get it by the last day of the preceding month, and we might have to wait an entire month if we're relying on a 30-day notice. So thinking about timeliness is really about organization, making sure that you have your documents prepared and ready to be served so that they can get to the tenant when they need to be. Delivery date is really important as well. So that's what we're talking about. So um, it's the plaintiff's burden to actually prove when the notice was given. So I've had some clients that are surprised to find out that mailing the notice to quit, ordinary first class mail, isn't sufficient. You actually need to have proof that they received it. I suppose the defendant in a later eviction proceeding might agree that they received it, and the honest ones hopefully would, but it's easy for them to say, oh yeah, I never got it. And in that case, you're stuck, because one of the elements of an eviction case that you have to prove is that the tenant actually received the notice to quit. So there's really two ways you can do it. The first one is certified mail with a return receipt. So if they sign the return receipt and you bring it to court with your notice to quit, that's sufficient proof that they received the notice. The best practice, and what I always do, is I serve by constable or sheriff. When that happens, there's a presumption of service that's irrebuttable. So if the constable says that they handed the tenant the document, or they left it at their last and usual place of abode, which is the technical term for they left it at their front door, as long as we have that return signed by the constable, it prevents the tenant from actually coming back and saying, oh, well, I never actually got it. So that's how I usually do it. It's cheap money to get that part of our eviction out of the way, and really beyond reach for saying that they never got it. There are some other issues we should talk about. One of the best situations is if let's say the lease is for a year and you're coming up on the year anniversary and the tenant doesn't move out, you actually don't need a notice to quit. The end of the lease was the tenant's notice to leave, so long as you don't accept another rent payment or take some other act which would create either a new tenancy or it would convert their existing tenancy to a month-to-month. I usually give what's called a 72-hour notice to quit, just to be sure. It's not required, but having that notice is helpful, especially for the court process. It's unusual not to have a notice to quit, and I think it's just good form to have it. It's not required, but it is good form to have it. And then occasionally this will come up if there's the death of a party. There's actually no statutory duration of the notice that's required. So as long as you're giving notice that the tenancy is terminated, as long as you give simple notice, that's enough. You don't have to give 72 hours. You basically just give a notice that says this person's died, tenancy's over, that's it. So 2020 and 2021 have changed things considerably. I'm not going to go over the Massachusetts eviction moratorium that has since expired in the end of 2020, but there are some changes at the state level that are still affecting evictions right now. The first one is Bill 5181. It was signed on December 31st of 2020, and it has a lot of requirements for non-payment notices to quit. So you have to include a copy of the CDC attestation, which is titled the Temporary Halt in Residential Evictions. So a lot of people will call this the CDC affidavit. We've probably all seen it. It's been all over the news. Basically, the Centers for Disease Control put out a regulation or a new rule that stopped evictions for non-payment of rent if certain conditions are met. So, for instance, if it's an individual and they make less than $100,000, if they swear that they've made best efforts to get public accommodations, if they say that they would be made homeless or they would have to live with somebody else. This is all designed to stop the spread of the virus. But what it does is it stops evictions from happening if that affidavit is served to the landlord. This only applies in non-payment of rent cases, which we'll get to in a second. But Massachusetts actually requires that the landlord tell the tenant about that protection. So they're going to get a copy of the attestation. They're going to get an attestation from the landlord, which says whether it's a covered dwelling under the CARES Act, which is relevant for something we're going to talk about in a minute. Documentation about agreements between the landlord and the tenant to repay the landlord. So if there's any sort of settlement agreement, or if there's something in writing where the tenant says, yeah, I'm going to repay X amount per week, they have to also include a copy of that. Additionally, they have to include information about rental assistance, including programs, including RAFT. So RAFT is basically a Massachusetts program that helps tenants that are unable to pay their rent come current, and in exchange, the landlord agrees not to evict the tenant for a certain amount of time. They also have to provide information about court rules and standing orders, relevant restrictions on residential evictions at the state and federal level. So if there's a new federal law that says you can't evict people for non-payment of rent, if there's a new statute, you have to tell the tenant about it, and you have to give them a very bold, all caps notice that says that it's not an eviction, you do not need to immediately move, you have rights, a court order can force you to leave, and that's it. So basically, you're telling the tenant all the best ways for the tenant to avoid being evicted, which is good protection. And so I'm not going to take a position whether this is a good idea or a bad idea. I think this is an unprecedented time, and we're just trying to do the best we can. But as a landlord, this is a difficult notice to send because you're essentially telling the tenant how to defeat your eviction and how to prevent you from actually regaining possession of the property through court process. Additionally, on top of all that, you have to send notice that you filed or that you served a notice to quit for non-payment of rent to the Executive Office of Housing and Economic Development. So my understanding is that this is to help the state understand how many notices to quit are being served. And it also gives information so that the state can reach out to tenants in appropriate cases. Beyond that, we have the CARES Act. So this is at the federal level. So the CARES Act only deals with covered properties. So that's property that meets, that gets certain federal assist or is part of certain federal assistance programs or is subject to a federally backed mortgage loan or a multifamily mortgage loan. So the landlord has to be sure to look and see whether their loan is federally backed. I would say it's extremely unlikely that you don't have a federally backed mortgage if you got what's called a residential loan or you didn't go through a commercial bank. Commercial banks usually hold their properties portfolio. They don't have federal backing, but I would say the vast majority of investment properties in Massachusetts are going to be considered covered dwellings. So the CARES Act requires that the person be given 30 days notice, and it also prevents any sort of penalties or late charges during the moratorium period. So the upshot of all this is the 14-day notice to quit is extremely rare right now. The only time you'd really see that is if it was not a federally backed mortgage that was securing the property. So if the landlord owns the property without a mortgage, or they got a loan from a commercial bank, they would be able to give a 14-day notice. But even then, you would still have to give all the notices that would tell the tenant how to defeat your eviction proceeding. So these days, the tips that I've been giving my clients really start with don't get creative. So I have no problem sharing my forms with my clients. I like to share my leases. I like to share my notices to quit because ideally, when they get to a point where they need my help, it's the documents I would have drafted anyway, and it makes my life a lot easier. So if I know the lease is valid, if I know that it complies with whatever law applies at the time, it makes everything easier to go forward with an eviction. So I would strongly suggest you don't just find something off the internet. It might not be tailored to Massachusetts. It might not have what you need. So at the end, I'll talk about how you can get in touch with me to get a copy of that form. Include the required notices and attachments under Mass law and federal law. So this is really important. If you don't include all the required notices, the notice to quit may be deemed invalid and you'd have to start over. So you give them 30 days notice. You've waited anywhere from 60 to 30 days depending on when you serve it. You then serve them with the summons and complaint. You wait a week. You file it with court. The earliest it could happen is about a week after that. Usually it's more like 3 to 6 weeks. You get to court and the judge says, you actually don't even see a judge on your first hearing. If you get to a first hearing, because it is a 14-day notice to quit, you could be several months down the line before you're told you have to start over. And then that's a really tough situation for a landlord to be in, especially if they're in a position where their tenants aren't paying and they need to pay the mortgage themselves. So that really can be the difference between having a property that performs and one that you might not be able to keep. The last point, and I think this is one of the most important things I'm going to talk about today, is consider terminating the tenancy for another reason other than non-payment of rent. So what does that mean? If the tenancy is terminated, or if the tenancy ends, so suppose I'm filming this in the end of February of 2021. If the tenancy ends on February 28th, That's great. Let's just wait until March 1st. We'll serve a 72-hour notice to quit. If you're not lucky, if you're 6 months into a 12-month term, I would strongly consider trying to find a violation to hang your hat on. And it's not always possible, but if your tenant is doing things that they shouldn't under the lease, so if the lease says no smoking and you have evidence of them smoking, you have a video of it, or you see cigarette burns in the carpet that weren't there, or there's cigarette butts all over the apartment when you're in there, that could be enough to actually go forward with what's called a fault-based eviction. You still have a 30-day notice to quit, but you can actually terminate the tenancy, and since it's not for non-payment of rent, the CDC moratorium doesn't apply, the CARES Act doesn't apply, none of the notices that we talked about apply, and it really just makes things a lot easier. The one thing I would caution is there's a little bit of uncertainty. The way that I interpret the statute, and I think the way that I've heard some judges talk about this, your notice to quit could be, let's say you gave them a 72-hour notice to quit because the term of their tenancy has expired. Just because that's what you write in the notice to quit, that doesn't mean that's what the law will consider your reason for eviction. So if you say, I'm terminating because your lease expired, but then you turn around and ask for $10,000 in unpaid rent, the court is going to treat it as though you're proceeding for a non-payment of rent case, and all those rules will apply, and basically you're not going to be able to proceed if they give you that CDC affidavit. So what a lot of people have decided to do is either write off that loss and say, I understand I'm not going to get paid, the tenant probably doesn't have the money, otherwise they would be paying it, and then if at some point in the future I want to actually proceed through small claims court or the district court, we can do that at a later point, but let's just get possession back and rent this property to the next tenant. So I just wanted to talk briefly about how I meet with my clients. I'm a little bit different than a lot of attorneys. So rather than just calling me and getting an appointment right away or meeting with me in person, I ask all my prospective clients to take a 10-minute questionnaire. It's really simple. It's questions like you see on the right-hand side. So name, address, city, state. It asks you about your tenant, why you want to evict them. If you have a copy of the lease, you can upload it. If you have a copy of a notice to quit, if you've already served one, you can upload that. We meet electronically, and you schedule it automatically after you take the questionnaire. So I meet over Zoom or telephone. We talk about your goals, what your pain points are. We talk about a strategy, and then I quote you for what I think it's actually going to take to do this eviction. So it's almost impossible to do evictions on a flat fee in a way that's fair to either party. I'm either going to have to pick a huge number to make sure that if this gets dragged out for 6 months, it's worth my time. And on the flip side, you probably don't want to take that risk. So what I've done with all my clients is I bill by the hour. Usually we can come to some range where it's what it's likely to cost, but that's unfortunately how I think most practitioners in this area are proceeding right now. My first consultation is always complimentary, so you're not going to receive a bill until you sign a fee agreement. And I try to keep as much paper in the printer as possible. I don't like to print things. So everything is signed electronically, and it can be a pretty quick process. So within a day, we can start working on documents, which can be really helpful for landlords that might need to have documents served quickly. So in the description of this video, you'll see a couple of links. One is for that questionnaire, and then the other is to actually schedule a consultation. So if you do need help, you're more than welcome to contact me. I've given you my email address and my telephone number, so feel free to reach out to me if you just need the forms. So if you said, Ben, I just need the notice to quit for a 30-day, I'm fine with that. I'm here to help, and I think at some point, if you do need help, you're likely to call me back, so it's all good. So if you have any questions, please reach out. Otherwise, it's been a pleasure. If you like the video, if you could give me an upvote, that would be really helpful. Consider subscribing to our channel, and I hope to talk to you in the future.